We are going to be looking into an important court case, the famous MEADS versus MEADS. I say famous because a lot of people who are seeking their fundamental rights and freedoms, their common law rights and freedoms, have been made aware of this case, or should be aware of this case. Now, there is much to be said and gleaned from walking through this case. This judgment was produced on purpose, with a direct reason for that action. The judge went through and quoted from close to 100 Supreme Court cases in order to drive the points home that he was making in his judgment. The amount of work that went into this judgment is a lot, and a lot of time also. It is close to 200 pages long and was created with intent and purpose. This is a judgment that is being used in the courts of Canada now to ask that cases which are deposited in court but have no operation of law, or that are built on improper mechanisms of law, to be dismissed from court. This judgment is the model example that the courts are using to determine whether an individual has been exposed to a false conception of law. This judgment is meant to describe and bring forth the qualities of a vexatious litigant. It is meant to show the courts the attributes of claims and cases that have no chance of succeeding, and where the individual applies to the court is using useless applications of law. The judgment claims to uncover, expose, and publish or bring to light the tactics used by OPCA litigants. Now, Section 4 of the judgment clearly states that. It says, the court has developed a new awareness and understanding of a category of vexatious litigant. I have collectively labeled them as organized pseudo-legal commercial argument litigants, OPCA litigants, to functionally define them collectively for what they are literally. One of the purposes is through this litigant to uncover, expose, and publish the tactics employed by the OPCA community as a part of a process to eradicate, to remove, the growing abuse that these litigants direct towards the justice and legal system we otherwise enjoy in Alberta and across Canada. This court case took place in the province of Alberta. I will respond on a point-by-point basis to the broad spectrum of OPCA schemes, concepts, and arguments advanced in this action by Mr. MEADS. The judge is using this specific litigant to expose and make a report about the many individuals in Canada who use pseudo-commercial arguments. These types of arguments are an abuse of the court's procedure and a waste of the court's time. Why? Because the court is declaring that these types of cases have no chance to succeed. Therefore, when applying to the court, it is wasting the court's time. This is a bold declaration, and a helpful one to many individuals seeking their freedoms, who may come across these individuals who are teaching these tactics. This judgment is going to be used to assist others who have been taken in and duped by these gurus to realize that these practices are entirely ineffective. Further, this judgment will assist counsel of the legal community when facing these litigants. Now, here a direct quote from the judgment in Section 6. Naturally, my conclusions are important for these parties. However, they are also intended to assist others who have been taken in and duped by gurus to realize that these practices are entirely ineffective, to empower opposing parties and their counsels to take action, and as a warning to gurus that the court will not tolerate their misconduct anymore. On February 15, 2011, Mr. MEADS filed a one-page notarized document printed in black and red ink and marked with what may be a red thumbprint. It also bears postage stamps in 3 corners on front and back and includes various declarations, including that Dennis Larry MEADS is a living flesh and blood sentient man, a postmaster general, and that Barb Petriak, a clerk of the Alberta Court of Queen's Bench, is appointed his fiduciary and is liable for all financial damages and bodily harm against himself, Dennis Larry, of the MEADS family. One of the tactics being used and exposed by the judge is the following. An OPCA litigant will file documents printed in black and red ink and marked with what may be a red thumbprint. It also bears postage stamps in 3 corners on front and back and includes various declarations. These are the signs that the court is looking for in order to deem or to judge that individual a frivolous litigant. If an individual has been taught, influenced, and duped by these gurus, they will think that by placing their thumbprint either in ink or blood will add some legal force to their documents. So this is exactly what they will do. And now, when the courts see such documents, they will automatically label them as an OPCA litigant. In the court's experience, in section 159 of this judgment, it states, there are no stereotypical OPCA litigants. They may be of any age or gender. Some are affluent, while others are not. Canadian case law reports OPCA concepts advanced by professionals, blue-collar workers, business persons, and retired individuals. Some travel in groups, while others appear to operate by themselves. The courts have realized that many individuals who are taken in by these false commercial arguments are already in a personal situation in their own lives to which they are looking for answers. This helps to motivate them to try these types of approaches. The motivation to adopt an OPCA approach varies. Certain OPCA litigants are clearly undergoing some kind of stress, such as a foreclosure on a home, a bankruptcy, disputes over child and spousal supports, deportation, or in response to large debts. The vast majority of OPCA litigants use highly stereotypical formats to name and identify themselves. The most common form adds atypical pronunciation, usually colons, dashes, into a name. Any litigant who uses this dash colon motive almost certainly has some kind of OPCA background or affiliation. The most common versions of this format are, they write their names like this: first name with a dash, your middle name, a colon, and then your last name. Or they write their first name with a dash, middle name, colon, and then a last name. The difference is the first alternative has an additional colon before and at the end of the name. Now here in section 207 it says, for example, OPCA guru David Kevin Lindsay styles his name as David Kevin Lindsay. Mr. MEADS also sometimes employs the clan, family, house name motive, but he combines it with the dash colon motive to create a hybrid. Dennis Larry of the MEADS dash family. The family, clan, house motive is also meaningless. So be careful, because this is a judge of the courts of Canada stating that when you use this type of written for your name on your document, that it's going to be considered meaningless, and that they're going to tag you as an OPCA litigant and say that you are coming from a commercial argument that has no force of law. And there's going to be some consequences to this now, and I'm going to show you later on what it's going to be. Another name-related indication of an OPCA litigant is that the litigant marks their name with a copyright or trademark indication. OPCA litigants frequently mark their documents in unconventional ways. The meanings of many of these marks is unclear, and these certain have limited or no legal significance. It may be that these motives simply are theater used by gurus to impress their customers and create what appear to be powerful documents. The judge is about to name a few actions that will indicate to individuals and the court system and the justice system as a whole that you are dealing with an OPCA litigant. If any of the following are being encouraged by an individual, then you should be careful. Section 215 of the judgment states, indications that appear restricted to OPCA documents include a thumbprint, typically in red ink, though in certain instances our court has encountered litigants who will injure themselves when presenting documents to the court clerks, so that they can make a thumb mark in blood. More than one signature, often in an atypical color ink such as red or green ink. This proceeding and attaching one or more postage stamps, sometimes the stamps have text or a signature written across the stamp. And in certain instances, these stamps are simulated and simply printed on the document itself. Mr. Meads, February 15, 2011 and March 3, 2011, documents show many of these unusual features. So if your documents include the above-mentioned indications, the courts in Canada will be aware and determine that you are an OPCA litigant and you are vexatious. The court or counterparty will seek to have the case dismissed due to this fact. They will now seek to further fine you and cause you financial damage. Any use or phrases such as accepted for value, accept for value and return for value, or accept for value and consideration and honor indicates an OPC affiliation, but not necessarily use of the A4V OPCA scheme. This language arises in multiple contexts when incorporated in a document. Many OPCA documents, including those of Mr. Meads, feature a declaration concerning such service, such as service to agent is service to principal, and service to principal is service to agent, presumably an attempt to expand the notification function of these materials. So if you write on your document that service to agent is service to principal, you will be labeled, you will be designated an OPCA litigant, and the courts will treat you as such. I see this all the time. Individuals teaching that notice to agent is notice to principal, yet they never have a law to back up what they are professing, a Canadian domestic law. Here, the judge specifically stated that if the phrase is included in the documents, you can be sure the individuals are OPCA litigants. The majority of the individuals teaching these false commercial arguments have no idea how to invoke their own fundamental rights and freedoms. Since they are unaware where an individual's freedoms are ensured and protected, they tend to use obsolete and irrelevant laws to claim their apparent rights. Many OPCA documents mention certain obsolete, foreign, or typically otherwise irrelevant legislation, including the Magna Carta. So, if you produce a document and you draw your rights, your natural rights and fundamental freedoms from the Magna Carta, you will be labeled an OPCA litigant, and your documents will be labeled OPCA documents. And there will be consequences to these actions now, and I will share them with you. Or, if you use the Universal Commercial Code of the United States of America, often simply identified as the UCC, this is sometimes mistakenly named the Universal Commercial Code, then you will be considered an OPCA litigant. If you use the Constitution of the United States of America, you will be deemed an OPCA litigant. If you use other American state and federal legislation to try and claim your rights in Canada, if you point to American laws and say, Canada, you are obligated now, you will be deemed an OPCA litigant. Now, they say that OPCA litigants also point to oaths of legislation such as the Alberta Oath of Office Act. They say that they draw their rights from the Canadian Bill of Rights, or from the Statute of Frauds, or from the 1931 Statute of Westminster, or the April 10, 1933 Order in Council that abandoned the gold standard for Canadian currency. So if you are basing your arguments as to why you have natural rights and fundamental freedoms in any of these, then you are going to be labeled an OPCA litigant, and the courts will treat you as such. Many of these teachers of these false systems do not understand that their fundamental rights and freedoms are protected through the Charter of Rights and Freedoms. Now, in 266 of MEADS versus MEADS, he writes, as a preliminary note, review of the case law and the court's experience indicates that OPCA concepts and arguments do not generally rely on the Canadian Charter of Rights and Freedoms. This may reflect the fact most OPCA concepts are adapted from American precursors, or that the typical OPCA litigant is unwilling to shield themselves under the authority of the Charter. They instead prefer to frame their arguments around the Canadian Bill of Rights, which has a well-established limited legal effect. When we are infringed or denied the right that is a direct trespass against us, what will be seeking is the administration of justice. That is what a real remedy is titled or called. We are seeking to have our fundamental rights and freedoms upheld because the executive powers have infringed upon them. Taking this action is called the administration of justice. When you look into the Supreme Court of Canada, Section 24, the Canadian Charter of Rights and Freedoms, Honorable Gerald Mitchell, January 2014, it states, the administration of justice, the central concern of Section 24 would appear to be the maintenance of respect and confidence in the administration of justice, as that may be affected by the violation of constitutional rights and freedoms. According to Grant, the term administration of justice in Section 24 concerns maintaining the rule of law and its process, and includes upholding charter rights in the justice system as a whole. An individual that has been denied or infringed upon their fundamental rights and freedoms, their natural rights, their common law rights, is seeking the administration of justice, is seeking to have his or her rights and freedoms respected. When walking into a court of law or beginning to speak with the court, this is the term and designation that you need to bring forth. I am here in court seeking the administration of justice. The reason why I'm here in court is I am seeking the administration of justice. There has been a violation against me concerning my constitutionally protected fundamental rights, and I am seeking a remedy. This has to be announced to the court. There are no special procedures, no secret documents or words that can be spoken to take control of the court. The simple fact of matter is that I am here in court today seeking the administration of justice. When you mention this, you place the court at attention. You place the court on awareness that you are here for this one specific reason. Now again, looking into the Supreme Court of Canada, from Gerald Mitchell, January 2014, in Section 8, you'll find that he states, the Charter itself contains no procedural direction, which is true. When you look in the Constitution Act of Canada, Article 24, it simply says anyone whose rights and freedoms have been denied or infringed, as guaranteed by this Charter, can apply to a proper court of law in order to obtain remedy. And I'm paraphrasing there, but that's the gist of it. And here, there's no procedural directions produced in the Charter. And this is what the judge is saying. When you look in the Constitution Act of Canada, the Charter itself contains no procedural directions. The absence of jurisdictional provisions and directions in the Charter confirms the view that the Charter was not intended to turn the Canadian legal system upside down. What is required is that it be fitted into the existing scheme of the Canadian legal procedures. There is no need for special procedures and rules to give it full and adequate effect. When we mention that we are here for the administration of justice, it is the court's responsibility to take note and to fit this claim into the existing scheme or structure of the court. When you mention that you are present for the administration of justice, the court's position is as follows. Remember, the court's belief or the court's position is all legislation, all domestic law, conforms to international law. And it is our responsibility as an individual to show them that this belief is unfounded. We are dealing with a court that presumes the executive powers are following international law, and when it comes to the rights and freedoms of an individual. When we look in R versus Hape, we find the statement, since it is a well-established principle of statutory interpretation that legislation will be presumed to conform to international law. It didn't say that legislation will conform to international law. It says the courts will presume that domestic law, the enactments and the regulations, that these conform to international law, that these are respecting our fundamental rights and freedoms. Now go on. One final general principle on the resolution of the legal issues in this appeal is it is a well-established principle of statutory interpretation that legislation will be presumed to conform to international law. The presumption of conformity is based on the rule of judicial policy that as a matter of law, courts will strive to avoid constructions of domestic law pursuant to which the state would be in violation of its international obligations. Courts believe, act, and presume as if the executive powers and the legislators are respecting fundamental rights and freedoms. This is the presumption that the courts are under. So it is up to you to prove to the court that this is not the case, that in fact and reality the executive powers have denied and infringed upon your fundamental rights. When you look in the reference RRS 193 and 195, you find it in the judgment on page 42, then it is important to note that the onus or the responsibility is on the person bringing the challenge to demonstrate not only the restriction of the rights, but also that the state has not abided by the principles of fundamental justice. And that is very important. You must understand and you must know what are the principles of fundamental justice here in Canada. It is the individual's responsibility to demonstrate the infringement or restriction of the fundamental right and freedom. The individual must also show that the state party has not abided by the principles of fundamental justice. This is your purpose to being before the court. You will need to walk the court through the restriction of your right, and you will need to walk the court through the principles of fundamental justice as it concerns the fundamental right and freedom you are seeking to exercise. What you are seeking to prove is that the executive powers have denied you your right to exercise your fundamental rights and freedoms, and you can term this a tort damage. A tort is a legal wrong. It may be either a direct invasion of some legal right of an individual or the infraction of some public duty by which special damage occurs to the individual. As one can clearly see, the denial of the right produces a cause of action, a tort. The denial of our rights gives rise or power to our fundamental right not to be deprived thereof. The trespass is indeed the source of our rights. It is the element that gives rise to our rights. It is the essential element for the administration of justice, which is upholding fundamental human rights and freedoms. The enforcement or vindication of our rights is the oldest of all causes of action in the law of torts. So you seek to exercise a right, and you're denied by the executive power. This denial gives rise to your right. This trespass is the source of our right. Now, you seek to exercise a right, and you must demonstrate that it's been restricted. And you must demonstrate that this restriction that the executive powers are doing are contrary to the principles of fundamental justice. When the state party infringes or denies us our fundamental rights and freedoms, this starts the process for us to invoke the administration of justice and to have our rights safeguarded. The denial of the rights creates the tort and provides us the reason to seek the administration of justice. Now, again, in another court judgment here, a cause of action is a set of facts which, if established, would entitle the plaintiffs to some form of relief. This is the modern judicial view of a cause of action. The plaintiff must first establish a cause of action, prove a restriction of the right, prove that it was against the principles of fundamental justice, and once he has done that, the question then becomes, what kind of relief is appropriate? Now, when looking into the case jurisprudence, word of the court, we find the following, and this ties in with MEADS versus MEADS. But it says, prior to the Charter's advent, the individual really had no special means of protecting against incursions upon his or her basic fundamental rights by executive or legislative arm of the state. Beyond making representations to the executive or administrative arms of the government, or petitioning and lobbying Parliament or legislators for changes in law. Linked as they were to concepts of parliamentary supremacy and sovereignty, there were no means at the disposal of individuals to muster court challenges aimed at invalidating legislative, executive, or administrative acts. Apart from these the individual's means of challenging incursions on fundamental rights were extrajudicial and of a precatory nature that were neither effective nor potent. Respect for the rule of law, upon which W. Ivor Jennings, in his text entitled The Law and the Constitution, points out at page 42 that the law and the Constitution hinges the existence of public order, and it mandated compliance with directive and ordinances even if they infringed upon individual fundamental rights and freedoms. So prior to the Charter, law was first and foremost for the mandate of public compliance. If they created a law, the individual had no means to challenge this law, even if it was stripping the individual of their fundamental rights and freedoms. Why? Because the purpose of law was for public order. However, since the Constitution Act of Canada, 1982, this has changed. A primary purpose of the Charter was to change this relationship of the individual with the state and its laws by endowing individuals with an effective means of challenging acts of the state in courts on the ground of violation of their constitutionally protected rights and freedoms. When the state party denies you the right to exercise a fundamental right or freedom, you now have the power and ability to seek a remedy with the court. The Charter itself produces this remedy in Section 24. Your only obligation is to demonstrate not only the restriction of the rights, but also that the state has not abided by the principles of fundamental justice. Now, when you look into the Supreme Court of Canada in M.A. versus Ryan, you will find this statement. It says that common law today, nowadays, since the Constitution Act of Canada, it must develop in accordance with Charter values. And a trespass in common law today equals an infringement or denial of a fundamental right or freedom. MEADS versus MEADS, in-court conduct, Section 242. OPCA litigants often engage in unusual in-court conduct. That seems to be, in part, because many OPCA litigants are following a script prepared by OPCA gurus. This was apparently true for Mr. MEADS. For example, at certain points in the court hearing, he appeared to read word for word from a prepared document. Other aspects of his speech seem rehearsed also. Now, common scripted motives include demands by OPCA litigant to see the oath or of office of a judge, lawyer, or court official. So they walk in there and they say, I'd like you to show me your oath of office. I don't believe you're a judge. I don't believe you have authority. Show me your oath of office. Or that the judge prove his or her appointment. So individuals are walking in before the courtroom and yelling and screaming at the judge, show me, prove to me that you're appointed a judge. I believe you're de facto power. You don't have the right to judge over me. Or the judge makes certain oath or statements, such as that the judge is a public servant. So they say, Judge, I want to hear you state that you are a public servant. State it on the record that you're a public servant. They also walk in there and they say they want to see the bond information of the litigant, of the judge or the lawyer or the court official. Or that the court indicate the basis or scope of its authority. So walk into court and say, I don't believe you have authority. You have no authority. You show me what authority you have. That the Crown provide proof that it has authority to proceed against the litigant. That an opposing party provide proof that it has authority to proceed against the OPCA litigant. Or for a certified copy of a documentation or legislation. That the court state whether it is addressing the litigant in one or two roles, such as whether to a legal person or a corporation, versus a flesh and blood person or a natural person. So these are all tactics that if you use within the court, or if you do within the court, they're going to label you an OPC litigant, and they're going to know you're an OPCA litigant. Now, if you understood where your fundamental rights and freedoms, and if you understood that the judiciary system is actually supposed to be there to protect you. That's the primary reason and the principal reason why there was a judiciary established here in Canada. Yes, secondarily, they're operating in a commercial capacity and they're in the business of security, valuable security instruments. But primarily, they are here independent from Parliament and independent from the government structure. It's an independent body, and it's supposed to be here for the administration of justice, working on our behalf. Now, documentation. OPCA litigants often present documentation to the court or other party at the hearing itself, without prior service or warning. Common examples include an attempt to present a judge or court official with documents to make a court a fiduciary agent, or foist a contract on the judge or court official. This proceeding and presenting the judge, the court clerk, or an opposing litigant with a fee schedule or other foisted unilateral agreement. So individuals are showing up to court and they're trying to file documents while they show up to court. They're not using the proper prescription of law to file documents. For example, if you've watched some of my videos, you will know that if you as an individual have realized that some of your fundamental rights and freedoms, some of your natural rights and freedoms, your common law rights have been restricted by the executive government, that you can now go to the judiciary, to the Supreme Court, to the court systems, and show them what has transpired, that there's been a restriction of your right, contrary to the fundamental principles of justice. Within that procedure, you would be notifying the Attorney General, whether 10 days in advance or 30 days in advance, depending on what right you were seeking to have respected. You wouldn't ever show up to court and automatically or just right there serve documents on them and say, I'm here and you must respect my natural rights. This would be well prepared in advance. Now, court authority or jurisdiction. OPCA litigants frequently deny that a court has jurisdiction over them or authority over them. That emerges in a number of ways. So they walk in there and the direct denial that the court has authority over the litigant, or identification of some physical element of the courtroom or court dress that indicate the court is military or admiralty. A statement or declaration that the court is restricted to certain domains of law, usually legislation, military law, and or admiralty law. So there are individuals who are walking in there and they're saying, you don't have authority over me, you are a military law, or you are an admiralty court, and therefore you don't have the right to judge over me. Or individuals are walking in there and saying the court is only a de facto court, or the judge is only a de facto judge, and you don't have any authority to judge over me. A declaration that the litigant's presence or participation is under duress. Well, I'm here under duress and stress. You're forcing me to be here, and that's why I'm here. No, you see, someone who would say this, they don't understand their fundamental rights and freedoms. They don't understand how to protect them, neither do they understand that the state party is under obligation to them. Because even if you were forced into court, you would have the power to stand up and seek the administration of justice against whichever party had brought you into court. Now, other in-court motives of OPCA litigants include a refusal to pass the bar. So they walk into court and they refuse to pass the bar. And they inquire whether the court is attempting to create a contract with the litigant. Or they refuse to enter or a premature departure from a courtroom. This is often accompanied by denial of the court authority. Or when the judges or the court are speaking to the individual, instead of actually listening and actually answering what is being asked of them, they have ritualistic responses to inquiries, such as a repetition of what seems to be formal, automatic responses. For example, I accept that for value and honor. Your honor, I accept it for value and return it for value for settlement and closure in this matter. So when the judge is trying to address this individual, instead of responding with a proper sentence, he keeps responding with the same phrases over and over again. If someone was doing that to you, if you were having a conversation with them and they were doing that to you, what would you think of that individual? Now, summary of in-court indica. The various motives are usually found in combination. A useful and representative sample transcript of OPCA litigant conduct is found in Canada versus Galbraith, and they tell you what page here. Now, the court says a particularly difficult category of OPCA litigant are those who adhere to the OPCA concept that all interactions between the state, courts, and individuals are contracts. As is later explained in greater detail, persons who adopt this concept will interpret almost any invitation by a court or compliance with court procedure as the formation of a contract. For example, members of this court have observed the litigants who apply the OPCA everything is a contract strategy will refuse simple court directions and processes such as to pass the bar, sit, stand, or acknowledge their identity. Similarly, litigants who refuse to identify themselves but claim to represent an entity related to the litigant will often maintain this role in the face of a strong court warning. These OPCA litigants are often very argumentative. So even though the court is telling them, listen, your behavior is not correct, and what you're doing is not correct, and the judge knows that you have learned this from some individual out there who have told you to behave like this in the courts, and by behaving like this, you will have some type of special treatment. The judge is trying to say, no, please stop doing that, and they continue on doing that, and they continue to frustrate the court. Now here is how they're going to deal with OPCA litigants from now on. Given the intrinsically vexatious nature of OPCA methodologies, which I review in detail below, it is appropriate that the court adopts special procedures for documents that show OPCA indica, which may include that the clerks reject the materials that do not conform with required standards, that the court clerk accepts and marks these materials as received rather than filed, that the materials that disclose OPCA characteristics may be reviewed by a judge without further submissions or representations by the litigant, and that the judge may declare that the litigant application or defense is frivolous, irrelevant, or improper, or an abusive process. Order that the documents are irrelevant to the substance of the litigation, but are only retained on file as evidence that is potentially relevant to cost against the OPCA litigant. So you're hearing that, to award costs against you for going into the court and using these operations of law that had no binding effect on the court and no power against the court. Vexatious status of the litigation and litigant, and or whether the litigant has engaged in criminal or contemptuous misconduct. So they're further saying that they're thinking about pressing criminal charges against those who use OPCA tactics. Now, the courts will reject the documents and order that if the litigant wishes to continue its action, the applicant or defense, the litigant then file replacement documentation that conforms to court formalities and does not involve irrelevant OPCA arguments, or order that the litigant appear before the court in a show cause hearing to prove the litigant has an action or defense that is recognized in law. That hearing need not involve participation of the other party or parties. So they'll call you in and they'll say, show me that you have proof of law. What they're looking for is the principles of fundamental justice. Now, they will assign fines as authorized by Rule 10.49-1. So this is a very serious matter now. If an individual is going to approach the court and they're going to be using these OPCA tactics within their documents, within their argumentation, within their operations of law before the court is now going to be assigning fines against you. The court is now going to be thinking about producing criminal charges against you. And the court is going to further think about potentially awarding costs against you towards your other party for what you are doing. So you need to be careful, and you need to make sure that how you draw up your claim before the court is done how you can enforce your fundamental rights and freedoms here. That you use the proper road, the proper mechanism that has been laid down for you. Now it says courtroom procedure responses to suspected OPCA litigants. OPCA litigants are known to engage in disruptive and inappropriate in-court conduct. So they go in there, they say that they take they record what's going on. They take recordings of it, even though the judge says, no, don't do it. And sometimes some of these individuals are even threatening the judge one guy, he threatened the judge, and this is what the judge did. While Justice Myers chose to give Mr. Larson the benefit of the doubt and assume that this was not meant to be a veiled threat, I think this effectively illustrates the potential activity that judges and court officials can expect when dealing with OPCA litigants. Now, I know most of the individuals that I've come across who are trapped under this category of OPCA litigants, they would never use harm. They would never use threats. But you see here, one guy did. He sort of threatened the court because why? Because he was under the impression that he has the authority and the power over the judge. He was walking in there with concepts on his mind and thoughts on his mind that he had learned out there that told him the judge has no oath of office, that the judge is a de facto judge, that he has no power, and that this man would have the right to go in there and overthrow him and take him off the bench. And in doing so, he would be doing a good thing for fundamental rights and freedoms. And while many of us might laugh at that and find that funny, this individual found that to be truthful in his own mind. And this individual could be dangerous in a court of law because of what he's carrying in his mind. Now, I'm just going to go on because I've read a lot here tonight for you guys, and I want to end this like this. Now, a lot of people are saying that the state, Canada, has no power, no right to apply their enactments or their regulations against you, and that they use the Magna Carta, they use irrelevant legislation, irrelevant laws, as we've seen tonight, to call on their freedoms. But the courts are saying here in Canada that that claim is frivolous, a claim that the relationship between an individual and the state is always one of contract is clearly incorrect. Aspects, and this is the judge talking, aspects of that relationship may flow from mutual contract. For example, a person or corporation may be hired by the government to perform a task such as road maintenance, but the state has the right to engage in unilateral action. You see, it's declaring it here. Now the state can engage in unilateral action, now watch, subject to the charter and the allocation and delegation of government authority. So the state, they can apply their enactments, their regulations, their rules against an individual, but their power to apply their enactments and regulations is subject to the charter. If the executive powers are trying to apply a statute or regulation that goes against your natural right, your fundamental right and freedom, you can prove that it is against the principles of fundamental justice. It is against international law and it's against charter-protected rights. And by doing so, the judiciary has to stand up and protect you. My rights and your rights as individuals, our common law rights, our fundamental rights and freedoms, our natural rights have been recognized within the Constitution Act of Canada 1982. And this charter now has changed the relationship between the executive powers and us as individuals. It has given you and me, as holders of these rights, the power now to challenge the executive powers, the power to challenge the legislators, that if they deny our rights, or if they create laws, enactments, regulations that strip us of our fundamental rights, we can challenge them, that they are of no force or effect against us. Thank you for watching my video, and I hope it cleared up some misinformation that is going on out there.